that he should be arrested because prima facie he is guilty of 339, omitting to note two things: that 339 is neither in the FIR nor in the police complaint. Only the learned judge finds it. And 339 is bailable. Please take my word, 339 is bailable. Please take my word, 339 is not in the FIR nor in the complaint. Please take trial. I may be wrong. Some court may hold me to be convicted. This is not a matter which you need arrest for, unless you want to humiliate me, harass me, read it with the utterances which I have read. You can achieve each and every object of your prosecution without arrest. Arrest is not your first choice. It should be the last resort if you are able to show to the court that I cannot achieve my objectives. 339 is a very interesting one. Leave it for a minute. But all of them till number 9 are bailable. Last column on the right. All of them. The meaning of bailable, of course, is that it's not automatically bail. You go to the police and they give you bail. That's the thing. I don't have to approach a court for it. All the 9 sections is point number 1. Point number 2. The impugned order has numerous errors. One of the errors at para 14 of the impugned order is a reference to section 339, saying that he should be arrested because prima facie he is guilty of 339, omitting to note two things: that 339 is neither in the FIR nor in the police complaint. Only the learned judge finds it. And 339 is bailable. In this case, petitioner Khera had claimed that the accusations he had brought are based on certain documents which he has in his possession. On the other hand, police claim that these documents are already detected to be false documents. Before a trial so quickly, after filing of the case by the informant, the petitioner has not made any claims that the police had made fabricated claims and that his documents are false. Now the claim of the learned Advocate General, who opposed B. Millers from the prosecutor's side, that the case of the petitioner falls in the category of 339 seems to have force in it. Please take my word, 339 is bailable. Please take my word, 339 is not in the FIR nor in the complaint. Also note, 339 refers to...
You have written bailable.
Yes.
This is where from we can find this. Fine is punishable by life. If it is an offense of 338.
Yes.
There is a distinction in that.
Can you give the book?
338 offense is there, then 339 is punishable by life.
May I just
337, then 339 is punishable by imprisonment up to 7 years.
So, matter of trial. I may be wrong. Some court may hold me to be convicted. This is not a matter which you need arrest for, unless you want to humiliate me, harass me, read it with the utterances which I have read. You can achieve each and every object of your prosecution without arrest. Arrest is not your first choice. It should be the last resort if you are able to show to the court that I cannot achieve my objectives. Now let's kindly go further in these sections. Just in this chart. In the chart. Not here, in the chart.
Chart supplied by you.
Yeah, this one. Yes, sir. So my lord has reached till 339, all of which are bailable. Now see below, 337, which is non-bailable, I have already made it clear that they are not records kept by the Government of India's public servant. 337 on the text is inapplicable. On the text is inapplicable. Then 338, another section pressed into service. Forgery of a valuable security, will or authority to make or transfer any valuable security or to receive any money. This is, the Lordship knows, I make a will, I give it to somebody, get some money in return, I make a contract, I get that kind of commercial transaction. Not a press conference where you're allegedly defaming somebody by use of a document. There is no money flowing. Then, the 353, public mischief. Well, simple answer. Alleged defamation is a bilateral offense. Your Lordship knows. Public mischief is a mega offense for the whole public at large, society at large. I am saying wrong things about you, Mr. XYZ. You are good, bad, black, white, all that I'm saying. That trial court will decide. Public mischief, doesn't arise in the text of it. Essential, on the right side, essential ingredient of 353 is group or class. I can even go against myself and say a class defamation of a big class. Your Lordship may consider it different. It creates a riot. a public mischief create, you say something about any religion. I am allegedly defaming him. In fact, normally your lordship will only hear the cause of action. Lordship knows, it's not a state offence. If he doesn't sue, he can't sue, Malas. Your lordship knows that. Then Malas, conspiracy, etc. Then 335 is making a false document I've given. On this, Malas, you are making errors. Now also see para 15 of the impugned order, Malas. Also, I've shown 14, clear error. Now see 15 also. And Malas, one more thing before me. Just see the entire judgment starts only from para 14. Just give me 30 seconds more on this, Malas. Impugned order starts only from para 8, page 8, para 14. I have given my anxious. Therefore, just see the. Neither of us, we cannot change it because the section is there. Just turn to the schedule. Just see the schedule.
Schedule. Yes. Page number.
It's the schedule 1, and it's the schedule 1 when your lordship reaches it's 339. Schedule 1 in the new BNSS. All right. What's the problem? Just come to the schedule, whatever act your lordship has. Having possession of a document, knowing it to be forged, with intent to use it as genuine, if the document is one of the description mentioned in 337. If the document, now on the right side, 7 years and fine, cognizable, bailable, magistrate of the first class. Read below that. If the document is one of the description for 338, imprisonment for life or 7 years and fine, non-cognizable and bailable. Well, we tend to forget that even life in prison can be bailable. This is legislative intent. Now, one very other third. This is what happens when you are putting all sections together. Now, there's another thing. 339 refers to 337. That means public records. Just see that, just above that, see 337.
Yes.
It is an alleged forgery of a record of a court of justice or of a registrar kept by a public servant of a government servant. And the government is to be the Indian government. Here the allegations relate to US government. Section 2 bracket 12 says the government necessarily, obviously, BNS is an Indian government. It can't talk of US government. But that is, my question is not that. I don't want to get into this. Having